Mr. Eric Ginder is going to talk to us for about 20 to 30 minutes about some laws that we see changing specifically on the eviction moratorium and foreclosure moratorium. Eric, are you there, my friend? I want to kind of just give you an opportunity to run through everything that's going on and then open it up to some questions. I know I've had a lot of agents asking about what's going on with the eviction and foreclosure moratorium.
Yeah, and the interesting thing about it is it changes on almost a week-by-week basis. We go from having one moratorium that's set to expire in 24 hours, and then 24 hours goes by, and like the one that we thought was going to expire gets extended, and two more get placed on top of that. So it's kind of a bouncing ball. But as of right now, there are technically 3 moratoriums that are out there that we should know about. And it's kind of easy because it starts at the federal level, goes to the state level, and then right down to the county level. So we've got, if this was a civics class, we'd be seeing all the forms of government working, at the same time here. So the easiest one to get out of the way is probably the federal one. And that's if you, watch, cable news and stuff, you probably saw the battle that was going back and forth upon that. That's what we call the CDC moratorium freeze or eviction freeze. I'm going to spend a few minutes on that one because it really doesn't matter to us. That is a federal case, and for those that didn't watch Saturday morning cartoons like I did, you've got your federal government and your state government, right? So California is our state government, the federal government's over all the states. And the federal CDC one has been declared unconstitutional by the Supreme Court. So like the big court, the biggest court in the land. How it got extended, I don't really know because, again, it was declared unconstitutional and invalid. Nevertheless, it was extended over the weekend into October. It really doesn't matter to us because the federal moratorium was really out there as a catch-all to the states that didn't have their own moratoriums. California does, so don't worry about the federal one, worry about the California one. So the ones that really affect us are California's, and then the sort of strange thing that was put in place by the County Board of Supervisors back in June. So let's take it again in order of easy. Let's take the county ordinance and deal with that one because in theory, that is going to expire in about 11 days. So before we talk about what it does, let's talk about its expiration. It was probably one of the more heavy-handed moratoriums that came down. It's the one that, if you've been talking about eviction moratoriums, this is probably the one you've been talking about. And it's the one that basically just said, look, you can't evict anybody for anything unless they are basically presenting a danger to health and safety, which means, they're getting hauled off by the police, right? So that being said, the interesting thing about that one, as wide-ranging and heavy-handed as it was, it had a self-expiring fuse of 60 days after the expiration of the last stay-at-home / work-at-home orders put out by the governor's office. And from everything that I've been able to tell, and I've Google searched this, I've looked at it, I've used every search engine there is, looked at it every different way I can. As far as I can tell, the last stay-at-home, work-at-home orders expired on June 15th. And from what I've read, and I've read the governor's webpage up one side and down the other, they've talked about it, but they haven't put any stay-at-home, work-at-home orders back in place. We've talked about masks coming back and stuff like that, but no stay-at-home orders right now. That being the case, this should be expiring, like I said, in 11 days. But let's talk about what not to do for the next 11 days that this ordinance is in place. So this ordinance was put out by the County Board of Supervisors. So again, those of you that like a civics lesson, that's the whole county. It's not the city of San Diego. It's not one of the discrete cities in San Diego County. It's the Board of Supervisors. It's the 5 people, Nathan Fletcher and the rest of them and all that. So they voted 3-2 back in May to put this thing into effect. And basically what it says is, housing being important, and the ability to know that you have housing and such is also important, that landlords can't evict tenants, nor can they terminate tenancies or use any kind of threatening language. I mean, I'm sort of dumbing this down a little bit for my own, edification here, but what it says is basically, if you're a landlord, you can't evict somebody, nor can you send them a letter terminating their tenancy, nor can you be calling them and saying, hey, you're going to have to get out, you're going to have to do this, you're going to have to do that. You can't really do any of that while this moratorium is in effect. And if you do, there's going to be penalties. So if you, for example, are a landlord and you start an eviction process, then this moratorium, or this county ordinance can be used basically as a shield by the tenant. The tenant just comes in and says, hey, county doesn't allow this, it can't happen, and the UD or unlawful detainer action would probably be dismissed. So let's talk. So no one's really going to do that, right? I mean, most UD lawyers are going to tell you don't file anything, this, that, and the other. But let's drill down into it a little bit and talk about the other things, like sending notices of termination of tenancy or talking to the tenants. So the ordinance was broad enough to say you can't terminate a tenancy during the time that this is in effect. And you can't terminate it even for what's called good cause. So good cause, if any of you have been to some of my other lectures or own property or just kind of know about this, good cause is something that came into play a few years ago when Governor Newsom was first voted into office. He signed statewide rent control, and also a law stating that you can only evict somebody now for what's called good cause. Before that, you couldn't evict somebody for bad cause, right? Like you couldn't say, oh my God, I didn't know you were of this color or of this sexual persuasion or of this religion. Now I'm going to evict you. Okay, that's pretty obvious. We haven't been able to do that for 100 years. So that's pretty obvious. But you could evict somebody for no cause. Like you could just get to the end of a year's tenancy and terminate the tenancy. And if the tenant said, why am I being kicked out? You didn't really have to say anything other than you're getting kicked out. Your tenancy's over. Thank you very much. Get out. And if the guy didn't get out, you sued him for unlawful detainer and kicked him out. Now, under the good cause, you have to give the tenant a reason why they're being evicted. And in some cases, that reason may not actually be good enough to get them out of the property. So some examples of good cause are, the easy ones are, I'm moving into the property, right? It's my property, I'm moving back into it. Or I've got a family member that's going to move into it. My mom, my dad, my sister, whatever, they're going to move into it. We're taking the property off the market. We're going to sell it. We're going to do whatever. We're taking it off the rental market. Or something like, hey, you're a bad tenant. You constantly break the rules. You're not paying your rent on time. I'm always having to, put 3-day notices out there. I get complaints. Maybe if it's a house or a condo or whatever, you're violating the CC&Rs constantly. Those are considered to be good cause too. But just a stock, I don't have to give you an answer, you're getting evicted, doesn't work anymore. Okay, so why have I gone through all that? Well, one, it's good to know. Two, it dovetails into this county ordinance, because the county is basically saying, we don't care if it's no cause or good cause, you don't get to evict. The only thing you get to evict on is, as we said before, health and safety problems. Somebody's running around with a gun or whatever. They're endangering the safety of the other people, in the neighborhood, something like that. So if you are in a position where you're saying, I want to move my family into the property, or I want to move back to the property, or I want to sell this property, and it's easier to sell it when, sorry, you're not in it. Those are no longer reasons that are valid with this county ordinance. So you can't terminate for that. And if you, call up surreptitiously and say, well, look, we don't really want you there anymore. I'm going to make life difficult for you, this, that, and the other. those are the types of communications that can lead if the tenant were to call like one of the many, agencies that have jurisdiction over housing, file a complaint against you, then you could be assessed fines, things like that. So anyway, it was a, like I said, a pretty heavy-handed little ordinance. It was challenged by lawsuit. It hasn't been alive long enough, really. I mean, it was kind of voted in I think, May, became effective in June, and looks like it's going to, die of its own, verbiage in August, which, as many of you know, is not enough time to work your way through the court system. So it may just simply be that thing goes away. It also may be that the Board of Supervisors decides to vote it back in some other fashion. They may say, wow, this has worked so well that we'd like to make it more permanent. And we're not going to have it sunset based on this 60-day period anymore. We'll have it sunset on something else, or maybe we just won't have it sunset. Who knows? I don't see that happening, but it's always a possibility. So anyway, so for the next 11 days until around, August 15th, this one is still in effect. So, if you've got a seller who was saying, I want to send a notice over right now terminating the tenancy, and I wouldn't do it. I'd wait. I'd wait until after this thing expires. If they say, well, I'm going to call the tenant and I'm going to have a conversation with them about this, I wouldn't do that either. And I certainly wouldn't do it if I were representing a seller in any, in any situation. Okay, so you've kind of got the nickel tour of the county ordinance. So let's talk about now the state one, because that's the one that we're going to have to live with a little longer. We've been living with it, for about a year. We're going to have to live with it a little bit longer because it was extended until the end of September, beginning of October. That's the one that comes out of the governor's office by way of signature. The legislature votes on it, the governor signs it into law, and it becomes, whatever, an emergency law. So that one was set to expire, as probably some of you remember, back in June. It was kicked out again until I think October 1st or the end of September, beginning of October, or whatever. And that one again, it's not quite as far ranging as the county one, which we figure that's the reason why the county one came into effect, is because the three people that voted on it felt that the state moratorium wasn't enough. What the state moratorium basically does is it doesn't really place a moratorium on evictions. Like unlawful detainer cases, evictions can go forward. You can give notice under the state one to terminate tenancies and so on and so forth. But what happens is if you give a notice, whether it's a notice to terminate the tenancy or a notice like the pay or quit notice, if any of you have been landlords or been tenants and not paid your rent, you're familiar with the 3-day notice to pay or quit. So now you can respond as a tenant to the notice to pay or quit with this affidavit, and the affidavit has to come with the notice. So in other words, I'm a landlord. I want to give you notice that you haven't paid your rent. And if you don't, that I expect you to quit the premises. And if you don't, I'm going to file an unlawful detainer action. So if I serve you with that notice, now what happens is you can respond with this affidavit saying, I can't pay my rent and it's COVID related. And there's a couple of details around that, like if I'm your landlord and I know, perhaps by way of your application, that you make more than $100,000 a year, or you make more than, I think, 130% of the county median, then I can actually ask you for proof of that. I can say, okay, well, show me why it is that did you lose your job? Did you get a pay reduction? Why were you paying rent at some point and not paying rent now? But anyway, that's kind of the one that's at the state level so far. So federal, and don't really worry about it. State, yeah, that's the one that's kind of more of an issue now. And then the county, which is, the sledgehammer, but looks like it's probably going away. So I've done a boatload of babbling here. I know that there were a lot of questions, so I'm going to kind of open it up to whoever wants to ask a question. But before I do that, I want to leave you with the text or advice or whatever that I give everybody when they send me the emails on these. And I probably answer 2 or 3 emails regarding unlawful detainers and such, a day from my real estate clients. And I always tell them the same thing. You should, this is great if you want this for your own edification. You want to be a more well-rounded real estate agent. You want to know these things. Fantastic. Don't give this advice to your sellers, to your property owners, to your landlords. Don't be telling them, oh, hey, on August 15th, you can just start evicting people. Hey, do this, do that. Don't do it. We are not here to give legal advice to the tenants or to the clients of the brokerage. Like I said, this is great stuff for your own understandings. It makes you, a better, more educated on the subject. It allows you to kind of, go through these things easier. But don't be telling the sellers, the landlords, this is what you need to do. This is how you do it. This is when you do it. Because if you get it wrong, and, it's a lot to digest, and there's lots of different ways to get it wrong, you stand a very good chance of having that seller come back to you and say, hey, I'm in trouble. You need to indemnify me. You need to pay for it. So with that happy note, questions?
Yeah, Eric, I know one of our associates just had he and I spoke, I think Monday night. He has a listing, and the seller called the tenant, and the tenant moved out. I'm sorry, he had the buyer. The seller called the tenant moved out, and the buyer is closing on the home, I believe, today. Is the buyer at any risk of, having that tenant move out? Because of phone calls kind of reminding like, hey, your lease is up?
So as far as we can tell, no. There's no punishment that really applies under any of these things, whether it's federal, state, or county ordinance. There's really no penalty phase that applies to anybody other than the landlord at the time, and potentially the landlord's representative, agent, attorney, whatever it may be. But yeah, a buyer who simply is told, hey, the tenant's going to move out on, August 5th, and he shows up, there's no tenant there. He moves in, puts all the stuff in place, he's what's called, an innocent purchaser for value. He's not going to have any issues with a former tenant who says, oh, I was forced to get out in violation of this law.
Fantastic. Sam, I know you got a call.
Quick question. I think a lot of us saw in the news that there was a cash for keys situation up in the Bay Area this last week, a $500,000 buyout on the lease. That doesn't apply to San Diego, obviously. I think you mentioned in a previous seminar that cash for keys, like tenants move out, we'll give you this amount of money. That was specifically blocked by the county commissioners, but that's not at the state level.
Okay, so I'm sorry, I heard pieces of that. There was a cash for keys buyout in the Bay Area, and it was blocked by the county supervisors.
No, it went through. It went through. I'm saying that the block on cash for keys is specific to the San Diego ordinance, right?
You're right. Yeah. So there's been a few other jurisdictions that have passed similar laws. Like in researching this for today, I found that LA, oddly enough, has something that's now fairly similar to ours. But yeah, that's county by county. So it's the county ordinance in San Diego right now that would prevent a San Diego landlord from approaching a tenant, in a San Diego tenancy, whatever house, apartment, whatever it is, from saying really anything. I mean, you would think, right, that a landlord calling up a tenant and saying, look, I really need you to go, and I'm willing to pay you. I'm willing to pay you like $10,000, if you leave. That really shouldn't send like shivers down the tenant's spine. But nevertheless, the way the ordinance reads is, if you cause the tenant any uncertainty as to their living arrangements, then you have technically violated this. So, if you were to be pulled up by, the Department of Fair Housing, and there was some complaint that was alleged against you or your landlord because they did this, and the landlord simply said, look, I didn't say I was going to kick them out. I didn't say I was going to file anything. I just offered them some money to leave. I mean, who knows? You might get somebody at Fair Housing to say, yeah, you know what, that's fair. But that's not the way the ordinance reads. So the advice that's being given to everybody now is don't do it, because the exact opposite could happen. The Fair Housing investigator could say, look, I don't care if you offered the guy $1 million, you still violated the law, and I'm still going to fine you for it. But yeah, so to answer what your original question is, yes, it's the San Diego ordinance that would make that potentially illegal to do. The state one, so let's say, for example, the San Diego ordinance expires when we think it's going to expire, on August 15th, and all we're left with really is the state moratorium. There is nothing in the state moratorium that says you cannot contact a tenant and offer them cash for keys or something like that. So yeah, I guess that was my 1,000-word way of answering what could have been done in 10 words, but hopefully that makes sense.
Yeah. Right up.
I have a question that I put on chat.
Okay.
Let's get to Fredo first, but
is it the one that starts with "I have a question"?
Yes.
All right. There we are. Okay.
Go ahead, Fredo.
How do we safely lead Jen around this? Who is Jen?
Lead generate. Salespeople.
Okay.
That's like what we're always like. How does this calculate into us getting more business, and how can we do it safely? I mean, you're talking to a sales team, right? So education that we get around this kind of stuff, how can we turn that into advice and something like that we can offer to our clients as we're calling people, circle prospecting, door knocking, but where we're not necessarily violating the law and offering legal advice?
That's a great question. And if I were a lead generation coach, I'd probably have some answers for you on that. But I suppose the way I would do it, if I were in your position, is, I would say, whatever, if you're a property owner, a landlord, and you're looking to sell, in these difficult times, call us. We have, legal resources, that we can consult, this, that, and the other.
Okay. So that's something that we could safely, bring you into a conversation with clients.
We can do that, or we can refer, to other people,
okay,
stuff like that. I mean, there's ways, obviously, to, try to set yourself apart. But what you don't want to be doing is you don't want to be literally telling somebody this is what you do, or, oh, it's okay if you do this or that, because you might make a statement that frankly was true, 2 days ago, and now all of a sudden it's not true because, at 10 o'clock at night, somebody passed something and somebody voted on it and somebody else signed it in the legislature, changing the whole thing. So, it's a good idea to kind of say, we've got, in-house legal counsel we deal with, and we kind of know this stuff pretty well. I mean, ultimately, you're going to want to talk to your own lawyer about to proceed, but we can kind of tee things up for you probably better than other agencies.
Perfect. That's beautiful. You crushed it at the lead gen coaching right there.
All
Thank
right.
you.
Okay, we can lead around now.
Fredo, go ahead.
What does the RPA have to, or what language in the RPA for somebody that is going to
locally international guidance?
The question, Eric, was what language do we put in the RPA for someone doing a transaction? Is there anything that we need to change on that?
Okay, anything to be put in the RPA to do what?
Regarding a rent back?
Yeah. So well, I guess the first question is that create tenancy. If they rent it back for 1 day, a month, whatever the case may be, and then what language should we put in there to protect the new buyer that's supposed to be moving in after the rent back?
Yeah, so Eric, he's referring to a rent back situation. We're seeing that a lot. And I think up to 29 days, Eric, if I'm right, it's not considered tenancy, but at the 30-day mark, you can't use the seller in possession anymore. And tenancy is created. Is that right?
La Joya International Gardens. Is Eddie speaking? Can I help you?
Does anybody else hear me?
Yeah. Am I understanding that right with a 30-day kind of like minimum to create tenancy?
Well, okay. So, yeah, you're half right on this because that's the way that CAR set it up. They use that seller in possession form, and they it's a little strange because the whole like myth of the 30 days isn't really true. Like that's not the magic number that sets forth a short-term tenancy from a long-term tenancy. It's one of the factors in it, but it's that in and of itself is not the determining factor. And you'll see that actually if you look at that form, because it even says like, despite everything that we've just said, we take no position on whether or not this is a short-term tenancy, a long-term tenancy. I think they try to characterize it as not even a tenancy, as a license to use the property or something. So there's they talk at, CAR has it all set up, and then they throw this like disclaimer going, well, actually none of this might be true, and you're on your own. And I don't want to get into it right now, but the differences between tenancies in which the tenant has possession, and that's the legal standard. If the tenant has possession of the property, then somebody has to give the possession back to the landlord, and that somebody can only be the tenant by way of saying, okay, I'm gone, here's the keys, or by a judge in an unlawful detainer case saying, I've rang my gavel, you have possession back, go get your writ of possession. So simply having somebody sign something saying, oh, we're only going to be there 29 days doesn't really do it, because there's other things that have to be done in order for that to be considered a short-term non-possessory interest, like a hotel, right? You don't have possession of your room at a hotel, meaning they can kick you out without having to do an unlawful detainer, right? Your 2-day stay is up, they come in, get your bags, throw you out on the street. That's legal. So that being said, what do we do with the RPAs and this, that, and the other to deal with the seller in possession type of a thing? So you can use the seller in possession form, but I think if you're representing a buyer in this environment, what you have to say to any buyer, and I know this is unfortunate, no one's going to love this, is you're going to have to say, we've got all this stuff set up in the forms. But the bottom line is we're in kind of a weird time here in California when it comes to getting people out of properties. So you might want to check with, an unlawful detainer attorney or something, just because there is a chance that you may not be getting possession of this. There's a tenant in there, there's a seller in there. If they don't leave at the end of that prescribed time, there's really not a lot you right now can do about that. And it's probably just a kind of a boilerplate warning that we start giving to buyers who are buying a property with a tenant, in it that says, I'll be out when my lease is up, or I'll be out when the, close of escrow date occurs or whatever, or a seller who says, hey, I need to stay 29 days or I need to stay 30 days, but I'll be out. That's probably the time where you want to discuss with that buyer and say, hey, just between you and me, let's hope everybody acts like adults. Everybody does what they've, promised that they'll do and committed to do. But the bottom line is you might want to have a backup plan, because it's harder than hell to get anybody out of a property right now.
Not a great answer. The reality is it's tough to get somebody out with that seller in possession.
Yeah, and that seller in possession form is meant to be kind of an aegis shield from any of the unlawful detainer stuff. Like, it's meant so that you can go to the police basically and say, look, this guy's not a tenant, he's a holdover seller, he doesn't have a lease, he doesn't have a possessory interest, kick him out. and hopefully you'll get the police department to say, yeah, buddy, you're trespassing, get out. I don't know of any police department or any police officer that will take that stance. I've been involved in a ton of these things over the past 20 years where the seller just doesn't move out, and the police come along and say, oh, it's a civil issue, you have to evict them. And that's not true. I mean, under California law, that is not true. They are not a tenant who has a right to the property. They are a squatter who just happened to have owned the property, 24 hours period for 24 hours before. But nevertheless, you can't force the police to do anything. So, these things wind up in unlawful detainer court. That's what this SIP form was meant to do, was meant to try to get, the sellers out with the use of police as opposed to the use of an unlawful detainer. I don't know of anybody who's actually put this form to the test and had it work successfully. I don't think it will. I think any judge that you put this in front of and you try to say, look, this isn't a tenancy, it's a license, they're just going to kind of laugh and say, yeah, it's a tenancy. Yeah, well, that's the best way to do it, is to give them some really, really serious motivation to get out. Like, saying, you're not going to be able to, to take some of the, your seller's proceeds. We're going to, hold a fair amount of your seller's proceeds back until you finally get out of the property. That kind of stuff is okay. But again, what we should be telling our buyers is something like that, is to maybe say, let's look at holding more money back in escrow. Let's look at some, ways that we can leverage the seller to get out of this thing, because even though we want to have faith in our our fellow man that they're going to do what they committed to do, yet there's no guarantee.
Yeah, Shayla, you had a question?
That's exactly what I was going to ask. Can you still hold that fund?
Yeah. Any other questions? I know this is a weird, tricky topic to navigate. It's almost like non-answered answered.
Yeah.
But it's important to know. It's important to know when we're taking a listing, or even when we're working with a buyer, with a seller in possession, what we're getting into. Any questions right now? Next week, we're going to talk about, Eric, it's my understanding that the foreclosure moratorium also expired on the 31st as well, right?
Yeah, so those usually fall hand in hand with the eviction moratoriums, because they try to keep them tracking together, because it's hard to pay your mortgage as a landlord when you're not getting paid any rent. So yeah, the thought is when the eviction moratoriums end, because built into the eviction moratoriums is a lot of other stuff, like the fact that the landlords and the tenants can access some of this federal money that's getting thrown around these days to compensate them for their loss. So when those things finally go away, then yeah, it's time for the moratorium on foreclosures to probably sunset as well.
Hey, before we break, so we've got a couple other things to cover. You said that the current statewide moratorium ends the last day of September. So what happens on October 1st? Yeah, so if you take Newsom at, I don't want to say his word because he didn't really guarantee this, but when he was asked, are you going to extend this again? And he said, that's very unlikely. Not to get too political, but I think a lot of this will probably, hinge on what happens with the recall. But on October 1st, if it has not been extended, I would imagine what you're going to see is, just a flood of unlawful detainer actions being filed. Okay. So there's, when we start discussing over the next 60 days, opportunity to go out and help folks that are going to severe need, buyers and sellers. Big round of applause for Eric Ginder. We'll continue to talk about this stuff